everyone. I'm Shreyash and I'm going to discuss your legal reasoning practice sheet. Let's look at the passage. This passage is talking about nuisance, which is a tort. Nuisance from archaic nocens through French nosa, nuisance from Latin nocere to hurt is a common law tort. It means that which causes offense, annoyance, trouble, or injury. A nuisance can be either public, also common, or private. So there are two types of nuisance, public and private. A public nuisance was defined by English scholar Sir J.F. Stephen as an act not warranted by law. An act that is not warranted by law, or an omission to discharge a legal duty, which act or omission obstructs or causes inconvenience or damage to the public in the exercise of rights common to all Her Majesty's subjects. Now, private nuisance. अब प्राइवेट न्यूसेंस के बारे में बात हो रही है. प्राइवेट न्यूसेंस इज द इंटरफियरेंस विद द राइट ऑफ स्पेसिफिक पीपल. Nuisance is one of the oldest causes of action known to the common law, with cases framed in nuisance going back to almost the beginning of recorded time. Under the common law, persons in possession of real property, like landowners, leaseholders, etc., are entitled to the quiet enjoyment of their lands. However, this doesn't include visitors or those who aren't considered to have an interest in the land. यानी जिनका उस लैंड में कोई रियल इंटरेस्ट नहीं है, they cannot sue for nuisance. This is what we understand from this sentence. This doesn't include visitors or those who aren't considered to have an interest in the land. Now, if a neighbor interferes with that quiet enjoyment, either by creating smells, sounds, pollution, or any other hazard that extends past the boundary of the property, the affected party may make a claim in nuisance. The boundaries of the tort are potentially unclear due to the public-private nuisance divide and the existence of the rule in Rylands versus Fletcher. Writers such as John Murphy at Lancaster University have popularized the idea that Rylands forms a separate, though related tort. This is still an issue for debate and is rejected by others. The primary distinction in Rylands concerns escapes onto land, and so it may be argued that the only difference is the nature of the nuisance, not the nature of civil wrong. In summation, nuisance means an unlawful interference with a person's enjoyment of property. Unlawful interference. Property right in the land is necessary for an action in private nuisance. Private nuisance is an obstruction to the right of private parties. Public nuisance is an obstruction to the right of public in general. So the last two sentences are very important. The second last sentence talks about private nuisance, and the last sentence talks about public nuisance. Let's look at question 1 now. Miss Prema lived in a house belonging to her husband's employer. Miss Prema's husband was a tenant, and she had a license to live at the property. Whilst using the lavatory, the toilet cistern was dislodged by vibrations caused by the next door neighbor's electricity generator, which fell on her, causing her injuries. She sued her neighbor for nuisance. Decide. Option A, she can sue for nuisance irrespective of her proprietary claim in the house. B, she can't sue as she lacks a proprietary interest over the house. C, it depends on the nature of the house whether it's a public or private property. Or D, interest in the property has no correlation with the suit for nuisance. Now, हमने बात की थी proprietary interest के बारे में. जैसे ये जो सेंटेंस है, अंडर द कॉमन लॉ पर्सन्स इन पोजेशन ऑफ रियल प्रॉपर्टी आर एंटाइटल्ड टू द क्वाइट एंजॉयमेंट ऑफ देयर लैंड्स. However, this doesn't include visitors or those who aren't considered to have an interest in the land. यानी अगर आप किसी लैंड पर विजिट कर रहे हैं जिसमें आपका कोई प्रॉपर्टी इंटरेस्ट नहीं है, यानी आप उसको ओन नहीं करते, तो फिर यू कैन नॉट सू फॉर न्यूसेंस. तो इसका आंसर होगा बी. वाई? Because she did not have any interest in the land, so she cannot sue for nuisance. ऐसा हो सकता है कि she has the right to sue for other things, पर nuisance के लिए proprietary interest होना बहुत ज़रूरी है, जो कि उसके पास नहीं है. So the answer would be B. She can't sue. Let's look at the next question. A large tower was constructed in the Docklands area of East London, which goes by the name of One Canada Square. A large tower was constructed. Residents in the area experienced interference with the television signals due to the construction. Some of the claimants were homeowners, whilst some others were family members, lodgers, and without a proprietary interest in the property affected. Decide whether interference with one's television reception amounts to actionable nuisance. A. No, interference of television signals does not constitute an actionable nuisance. B. Yes, television signals are a property, thus, any interference with the same constitutes nuisance. C. No, building a tower upon a land is a legal right, thus, obstruction is a natural concomitant. Or D. Residents ought to shift to other television operators providing seamless services. To answer this question, we have to look at the passage. To the meaning of nuisance. अब न्यूसेंस का मतलब है कि आपके पास कोई रियल प्रॉपर्टी है और उसके क्वाइट एंजॉयमेंट में ऑब्स्ट्रक्शन कॉज हो रहा है. सो इस क्वेश्चन का सब्जेक्ट मैटर है टेलीविजन सिग्नल्स. तो आपको ये सोचना है कि क्या टेलीविजन सिग्नल एक प्रॉपर्टी के क्वाइट एंजॉयमेंट के लिए एब्सोल्युटली इंपॉर्टेंट है. क्या वो प्रॉपर्टी बिना टेलीविजन सिग्नल्स के एंजॉयमेंट उस प्रॉपर्टी का हो सकता है या नहीं. सो it would only be logical to say that in order to enjoy a property, in order to enjoy the proprietary interest that you have in a property, doesn't mean that you have to enjoy TV signals, right? So this rule also applies to light, air. अगर आपके पास आपकी प्रॉपर्टी के बगल में किसी ने बिल्डिंग बनाई जिसकी वजह से आपकी प्रॉपर्टी पर लाइट नहीं आ रही है या हवा नहीं आ रही है, तो इसका मतलब नहीं है कि दैट इज न्यूसेंस. दैट मे बी एनीथिंग एल्स, बट दैट इज नॉट न्यूसेंस. सो द आंसर वुड बी no. Interference of television signals does not constitute an actionable nuisance. Let's look at question 3. Vimal incorporated a company named Vimal Metal Mart. VMM generates a great amount of metal waste during the course of repairing and maintenance of plant and machinery. The VMM dumps the metal waste in a nearby place, assuming nobody will notice. Dumping, however, backfires sometimes. For example, once VMM tried dumping the waste on the road adjacent to the business premise, it ended up blocking it partly, causing difficulty to vehicle users and passers-by. Can the road users in general sue VMM for private nuisance? आपको यहाँ देखना है कि प्राइवेट न्यूसेंस के बारे में पूछा जा रहा है. तो इसका जवाब देने से पहले लेट्स लुक एट द एंड ऑफ द पैसेज जहाँ पे प्राइवेट और पब्लिक न्यूसेंस को डिफरेंशिएट किया गया है. प्राइवेट न्यूसेंस इज एन ऑब्स्ट्रक्शन टू द राइट ऑफ द प्राइवेट पार्टीज एंड पब्लिक न्यूसेंस इज एन ऑब्स्ट्रक्शन टू द राइट ऑफ द पब्लिक इन जनरल. तो इस क्वेश्चन में क्या पूछा जा रहा है? कैन रोड यूजर्स इन जनरल सू फॉर प्राइवेट न्यूसेंस. तो क्या ये प्राइवेट न्यूसेंस है? अगर रोड पे ब्लॉकेज है किसी तरह का, तो क्या ये आपकी प्राइवेट प्रॉपर्टी से रिलेटेड है? नो, this is concerned with the use of the public because the road is a public property. So although it may amount to public nuisance, that is debatable, but इस क्वेश्चन में प्राइवेट न्यूसेंस के बारे में पूछा जा रहा है. तो क्या ये प्राइवेट न्यूसेंस है? नो. So the answer is C. No, the road users cannot sue for private nuisance. Question 4. It has the same facts. The only difference is, can the road users sue VMM for the tort of public nuisance? Obviously, yes, they can sue the VMM for public nuisance. Why? Because the road is a public property and no one can be excluded from its use. So the correct answer is A. The fifth question asks, Suter Peck was the owner of a large country house with over 1,000 acres of land. This land was close to a copper smelting factory which had no longer been in operation. The smelting factory discharged noxious gases as a result of its operation, which were considered to be a normal part of the smelting operation. As a result, trees on the claimant's land were damaged by the fumes and noxious gases. The Suter Peck sued for nuisance. Whether the factory was liable for causing nuisance? A. Yes, the factory is liable for nuisance for causing discomfort due to the release of noxious gases. No, Suterpec's claim of nuisance won't be entertained as Suterpec itself came near to the nuisance source. C. Real estate businesses should be aware about the surroundings. Suterpec is the wrongdoer. Or D. Yes, Suterpec's claim will succeed as the factory has violated the right to clean environment under Article 21. तो इसका आंसर तो ए होना चाहिए यस द फैक्ट्री इज लाइबल फॉर न्यूसेंस फॉर कॉजिंग डिस्कम्फर्ट ड्यू टू रिलीज ऑफ नॉक्शियस गैसेस बिकॉज facts में it is very clear that the factory is releasing noxious gases and it is passing to the neighbor due to which the trees are being damaged. So this is a clear case of private nuisance. So the answer would be A. So this completes our passage. I'll see you next time with a new practice sheet. Thank you.